Hello, this is Professor James Strickler, and this is a course in American government. This lesson is from Unit 7 about the judicial branch. It's Lesson 2 about trial by jury. In this lesson, you'll learn about trial by jury, about petit juries, about grand juries, and about indictments. In this lesson and in lessons to come, we'll be learning about the judicial heritage that the American court system have inherited from its English ancestors. In the previous lesson, we learned about the common law. In this lesson, we'll be learning about trial by jury, an idea that our American court system inherited from its English predecessors. Back hundreds of years ago in Europe, the efforts that were made to figure out whether somebody was guilty or not of some offense were called trials. One method of trial that was used at the time was something called trial by ordeal, where people would be put in some sort of harsh situation, and the way that they and their body reacted to it would be used to judge whether or not they were guilty or innocent. For example, they might have to reach into a pot of boiling water and pull a stone out from the bottom. And then they'd look at them in the days to come to see how quickly the burn on their hand healed or didn't, to figure out whether God approved of them or not, and therefore why they were guilty. In the illustration in the background here of this slide, you see someone going under ordeal by water, where they were thrown in a body of water, and if they sank, they were considered innocent, and the ropes were used to pull them out. And if they floated, they were thought to be guilty, and then they were punished appropriately. Another type of trial that was used hundreds of years ago in Europe was trial by combat, where a couple people that had to dispute would be put in a small arena with each other, and the one that defeated the other was considered to be favored by God to achieve victory, and therefore they were the ones with the right side of the cause that should be the winner of whatever the legal dispute was. Here we have an example where a man and a woman are being placed in combat with each other to determine guilt or innocence. The man was handicapped in fighting the woman by having to stand in a hole. So again, this shows the sort of odd ways that they tried to figure out whether people were innocent or guilty at one time. Eventually, they began to develop what we would, from our modern point of view, consider more proper ways to figure out this question of guilt or innocence. One example that we already saw in this course can be found in the Magna Carta. Remember, the Magna Carta was a document signed by the English king 800 years ago that established limitations on his power. Among the limitations we talked about was that the king could no longer seize or imprison the barons who had forced him to sign this document unless there was a lawful judgment made against them by their equals. In other words, unless they were found guilty by a jury, as we think of it in our modern sense. So from agreements like this and other cultural developments, we began to see the development of trial by jury in Europe, including in England, where you would have a group of people that would decide whether or not someone accused of some offense was actually guilty and should suffer a punishment. In our modern concept of juries, they are composed of random citizens that are selected to then decide whether or not their fellow citizen is guilty of whatever it is that they're accused of. Now, this jury system that we've inherited from England, that developed there over centuries, is viewed by some people in the world as rather crazy. And the reason is that when you select a group of random people to decide whether or not somebody is innocent or guilty of a crime, you're possibly selecting stupid, ignorant, biased people to make those decisions. Those kind of concerns led the famous author Mark Twain to criticize the jury system as something that was designed to defeat justice and wisdom. Now, maybe that's going a bit far, that it was designed to do that. But there's many people that think that that's what it ends up accomplishing. Because you bring in these people who are ignorant of the law, perhaps ignorant of the expertise they need to be able to even understand the case. Perhaps they don't have the intelligence. Perhaps they're biased in some sort of way. And they are the ones that are then depended upon to render justice. Wouldn't it make more sense to have some sort of experts, perhaps judges that are trained in that particular area, sitting over on a case to decide who wins or loses? That's how most of the rest of the world does it. It's generally only those countries that, again, like when we talked about the common law in the previous lesson, have inherited their judicial systems from England, where this idea of juries is commonly used. Now, even though there's lots of reasons to potentially criticize trial by jury, there are some very important reasons why it is considered so important in the United States of America. And what it essentially comes down to is that we Americans view it as a check on tyranny. Back at the time leading up to the American Revolution, as the British government began to try to assert its control over the colonies, started imposing rules that the colonists started to balk at, they ended up finding that in many cases their last best protection against tyrannical laws was to have juries of their fellow citizens let them go. Here's an example of a famous case in which a newspaper publisher was arrested and charged with essentially criticizing the governor and government of New York. And in his defense, he said, but what I was saying about them was true. The judge ordered the jury in the case to say it doesn't matter whether what he said was true or not. What he said was in violation of the law, and he should suffer the consequence. Well, the jury quickly let him go anyway. And this was upheld by many people as a victory for liberty, particularly the liberty of freedom of the press. The idea that people should be able to criticize government officials, whether the law says they should or not. In this case, the jury was the line of defense that allowed this man to go free, that stood up to tyranny. Some of the founding fathers thought the jury system was essential to preserving the principles of our Constitution, as we, the people, the true sovereigns of the country, would be the ones that decide whether our fellow citizens go to prison for violating laws, rather than the government itself deciding. Now think about that. That's a very important thing. The government passes laws, but they aren't the ones that decide whether you go to jail for having broken them. Instead, it's your fellow citizens that do in a jury system. Effectively, they are still acting as the sovereigns, telling the government what to do rather than the other way around. And this is considered a fundamentally important thing to our system of government. It's considered so important that the right to trial by jury is directly protected in the Constitution itself, in multiple places. Here's but one example in Article 3 that sets up the judicial system of the United States, where it says all crimes, other than cases of impeachment, shall take place before jury. Now, it's talking about crimes against the national government here. But that's a wonderfully important indication of just how important juries were considered at the founding of the United States of America as a basic way to check the power of a government that could be acting oppressively. Now, when we talk about juries in the United States, we have to be careful and actually separate it into two categories, because there's two kinds of juries that exist. There are what are called petit juries and what are called grand juries. And we're going to talk about both of these separately. Now notice the color code on this slide here. The slides that follow that have the green background are going to be talking about petit juries. The ones with the yellow background are going to be talking about grand juries. Now keep in mind what those words petit and grand mean. Petit means small generally, grand means big, and you'll see why as we go through here. A petit jury is what you think of as a jury. It's what you see as a jury in a movie or on television. A group of people sitting in on a trial, participating in it. A petit jury typically consists of 12 jurors. Now, that isn't always the case. Depending on the particular state and the particular kind of thing being tried, it can be as few as 6 people. But usually it's 12 people on a petit jury. Now, if 12 is petit, that's going to begin to give you an idea of how big a grand jury is. A petit jury, when they serve on a single case. So, if you are randomly selected as a citizen to be on a jury, which is usually done through driver's license records. That's how the local government selects who they want to come in to sit on cases. If you are called to jury duty and you're on a petit jury, you will serve as a juror for the one case that jury is being seated for. If the case takes 20 minutes, you're done in 20 minutes. If it takes the next 6 months, you're going to be there every day for the next 6 months till it's decided. On a petit jury, you serve for one case. And the job of that petit jury is to decide whether or not the person being accused is actually guilty or innocent. And how do they go about doing that? Typically speaking, petit juries have to be unanimous in their verdicts. So the 12 jurors, after hearing a case, they go back for jury deliberations in a room by themselves, and they talk it through. And they try to convince each other until finally they reach a unanimous decision on whether or not the person accused in the crime should be accused in the trial should be found guilty or innocent. That is how a petit jury works. A grand jury, notice we've now switched to the yellow background, a grand jury does something different. Now, here's a picture of a grand jury from in California. Notice how big it is. This is over 20 people. This grand jury has a very different job from a petit jury. And when you are called to jury duty, you could potentially be called to either jury duty, either on a petit jury or on a grand jury. A grand jury typically consists of 20 or more jurors, although in some jurisdictions it may be less and some it may be more. And they sit for a specific period of time. They're not there just for one case. Maybe they're called for a 2-month period, and every day they have to go in for the 2 months. Now, you may be thinking about this as I'm talking about how these juries work. You say, well, wait a minute. If I get called to jury duty, how do I go in every day for the next 2 months if I've got school to go to or work to go to or whatever? Well, theoretically, legally speaking, when you're called to jury duty, you're obligated legally to go serve on the jury. But they give you lots of exceptions, ways to get out of it. If it's going to cause a hardship for you. So, for example, I'm taking college courses, I can't miss my exams, therefore I can't be on the jury. They'll let you off. I am working, I can't afford to miss work, I need the money to pay my bills. They'll let you off from jury duty. That's why in the previous photo about the grand jury, you may have noticed that most of the people on that photo looked like they were retired. Those are the kind of people that can most easily serve on these juries. But anyway, back to the idea of a grand jury. Unlike a petit jury that just sits for a specific case, the grand jury is going to be there for a certain length of time. The reason is because they're there to hear a series of cases. And when they're hearing those cases, they are not trying to decide the guilt or innocence of the people involved. So what are they doing instead? They're trying to decide whether to even bring charges against the people. So the grand jury is actually a step that occurs before a petit jury. Now, I talked about the grand jury second because most people are familiar with what petit juries do. They've seen them in movies, they've seen them on television shows. So I wanted to talk about them first, since you're probably familiar with them, but really grand juries come before that in the process. What happens is the police think they have some evidence that maybe somebody is responsible for a crime. Then that evidence is presented to the grand jury. The grand jury looks at that evidence that's been collected, and they try to reach a decision on whether to even bother to have a trial. And basically the thinking is if we've only heard one side of this case, we've only heard the side that's trying to throw this guy in prison, for example, and if we only hear that one side and we still don't think he did it, there probably isn't a reason to even bother to have a trial. He'll be found innocent no matter what. So let's not waste the taxpayers' money and even have a trial. That's basically the kind of thing that the grand jury is trying to decide. Should we even bother to have a trial? And they can go through cases fairly quickly on that basis. They hear the evidence from one side, they don't have a bunch of cross-examination, they don't have defense witnesses, things like that. And so they hear the evidence on one side and they make a decision, should we even bother to have a trial? They make this decision by a majority vote. They don't, unlike the petit jury, which is actually sending people to prison. The grand jury doesn't have to be unanimous. Again, they're just deciding should we have a trial, not whether this person should go to prison. If they decide no trial, then the person goes free. So it's not as serious as of a decision, so they do it by a majority vote. What they then do is if they decide that this person should have a trial, they issue what's called an indictment. An indictment is a formal accusation that the person has committed a crime and therefore should be tried and potentially, if they lose the trial, go to prison or receive whatever other punishment they might receive. That's what grand juries do. They decide whether to have trials, and if they think there should be a trial, they issue an indictment, which is a formal accusation against the person. So now let's review what you learned in this lesson. What happens in a jury trial? Does a judge decide the outcome of the trial? Or does a group of citizens decide? Or does the public vote on who wins or loses? Or is there no decision rendered in a jury trial? In a jury trial, a group of citizens decide who wins or loses. What does a petit jury do? Does it ratify the judge's decision or otherwise endorse what the judge did or say it's wrong? Or do they train to become a real jury? Or are they the ones who bring charges against somebody? Or do they decide if the person's actually guilty? A petit jury decides guilt. What does a grand jury do? Does it ratify the judge's decision? Or are they training to be a real jury? Or do they bring charges? Or do they decide guilt? A grand jury brings charges. So remember, the grand jury actually comes first in this process. They're the ones to decide whether the person should be even charged with a crime. Then a petit jury is the ones that decide whether they're guilty. What is an indictment? Is it a formal charge of a crime? Is it a decision of a petit jury? Is it a trial by ordeal? Or is it the ending of a criminal trial? An indictment is a formal charge of a crime brought by a grand jury. That completes this lesson. The next lesson will be from Unit 7. It will be Lesson 3 about criminal law.